Don't worry, I will not address everything which is collected between collective redress and private international law, but I will mainly focus on jurisdictional issues in this regard. But before starting, I would like to give you an idea where we are standing with regard to collective redress and the Brussels I bis regulation. This is one of the most discussed topics at the moment. It is so much discussed because we have case law, and it's so much discussed because case law has triggered legislative activities of the Commission, of the Council, which is now pending. So the latest document regarding the new directive on collective redress is 10 days old. And tripartite negotiations between the Parliament, the Council, and the Commission will start in the next weeks. So it's a very topical issue. We will look a little bit at the sectorial approaches where the European Union has already adopted instruments. And finally, I would like to demonstrate to you how a feasible solution should look like. So let's start with a state of affairs. What are we talking about? It's all about diesel scandal. And when we look at the diesel cases, we have two different types of disputes. The first wave of lawsuits related to shareholders' suits. So shareholders who had lost money because, of course, the value of the share of Volkswagen dropped down the moment the scandal came up, they try to recover damages because they invested into the wrong shares. And they pretend we have not been sufficiently and adequately informed. So here we have a lot of litigation going on. From the perspective of the Brussels I bis regulation, one issue which has been discussed a lot was a question whether there is an exclusive jurisdiction clause in the statutes of Volkswagen leading all cases to Braunschweig. Braunschweig is a district court where Volkswagen has its seat. So this was something which was decided only half-heartedly by the Austrian Supreme Court, who finally told the Austrian investors that they had to go to Germany. In Germany, there is a specific law for the protection of investors. It also provides for exclusive jurisdiction at the seat of the company. The problem is that in the Dieselgate case, you have several companies which are involved. It's Bosch, it is Volkswagen, it's Daimler Chrysler, it's Porsche, it's Audi. They have different seats in different parts of Germany. The question is, which court is a competent court? And jurisdictional issues here regarding local jurisdiction have held the courts busy for almost 2 years. So at the moment, most cases are pending at the Court of Appeal in Braunschweig, and the next hearing will take place in December. The second part of the Volkswagen and diesel scandal is about the lawsuits, and you are all aware of this, who are brought by consumers or customers who bought Volkswagen cars. And they also want to get some compensation. The German lawmaker has even enacted a new law which shall protect these purchasers. It entered into force last year, and it enables a consumer protection association to bring a claim for the declaration of liability in one court for all pending cases, and all other cases can be registered in public registries, and several thousand, 100,000 cases have already been registered in the German central register for those cases. As far as I know, we have 410,000 cases registered there. But the problem is, of course, whether all these claims are really admissible or not. Last information regarding the Volkswagen drama. No, we can go here. There might be settlement negotiations starting in the next months. The Court of Appeal in Braunschweig has strongly recommended to start negotiations, and it might be that they settle. At the same time, you already heard it, there are also cases already pending in the European Court of Justice. This is an Austrian case brought by the Austrian Consumer Protection Association on behalf of several hundred Austrian consumers who bought Volkswagen cars. This claim is based under Article 7, number 2. You have already heard about this provision. Here the problem is as follows. In Austria there are 16 different district courts. And the problem is that Article 7, number 2 does not only apply to international jurisdiction, but also to venue, to local jurisdiction. So the Consumer Association had to file parallel lawsuits in all Austrian districts because the consumer were located in all parts of Austria. And only one court sent a preliminary reference to the Court of Justice. It was the Landesgericht Klagenfurt, and all other cases have been stayed at the moment. So we will see whether the negotiations between Volkswagen and the plaintiffs' organizations are quicker than the decision of the Court of Justice in this case. Second constellation of mass harms, mass claims, flight cancellations. It has also already been addressed. Just to give you a dimension, I recently talked to the president of the Court of Appeal in Düsseldorf. Düsseldorf is one of the most important venues for flights from, let's say, Spain and other touristic hubs to Germany. And the president of this court told me that in the local court of Düsseldorf, they have an augmentation of cases per year by 10,000 only because of these flight rights. And the case law of the court, which facilitates bringing cases in the Düsseldorf local court, of course, has impacted on the factual situation in this regard. When it comes to flight rights, we have very often platforms which help consumers to bring their claims. They are very often commercial platforms, and we also have experienced some abuses. Just to give you one example, it was the case Flight Refunds, where a passenger took a plane from London to New York. It was delayed, and a commercial platform filed a lawsuit against the airline, which was Lufthansa, in Hungary, before a Hungarian notary. And it ended up with a Court of Justice, and one could see that this was obviously an abusive case because there was no connection at all with Hungary, and they argued a little bit with the Convention of Montreal, which was to some extent maybe applicable. Next area where we have mass claims is the General Data Protection Regulation. And here we have one famous activist who has become a recurrent visitor of the Court of Justice in Luxembourg, is Maximilian Schrems. And Maximilian Schrems tried to bring a case against Facebook before the Austrian civil courts, saying that he was a consumer, that he was using a private Facebook account, but he did not only sue in his own name, he had also opened up a web page, Facebook of course, where other consumers could assign their claims against Facebook to him, and he brought not only his own claim, but in fact several thousands, but he only came up with 15 parallel claims. And finally, the Austrian Supreme Court sent the case to the Court of Justice, and the Court of Justice had to decide whether jurisdiction for consumers was applicable not only to Mr. Schrems, this was an easy part, but also to all the assigned claims. And in this case, Advocate General Bobeck made a very clear statement by saying, or by telling the court, if you go in the direction that all the assigned claims can also be brought at one of the consumer's home, then you will open up the Brussels 1 bis regulation for a new kind of collective litigation. Is this really your task, or should the EU lawmaker step in? And interestingly enough, the same day, the court gave its judgment in Schrems and said, no, the assigned claims cannot be brought under Article 18 of the Brussels 1 bis regulation, not at the place or the home of one consumer. The European Commission came up with a proposal for collective redress in consumer affairs. So there is this interplay between the Court of Justice and the lawmaker, and here it was certainly up to the lawmaker to step in. In the meantime, the situation has changed again. Now we have the General Data Protection Regulation, and there we have specific norms which facilitate collective redress on behalf of consumers, which are not easy to align with the jurisdictional heads of the Brussels 1 bis regulation. So here we are. These are the latest developments concerning collective redress as proposed by the European Commission. They started in April 2018 and proposed a directive which shall expand the scope of the current consumer protection regulations in procedural matters further. And the main ideas are as follows. The Commission wants to include not only injunctive relief, but also compensation. So this is a broadening, which is, of course, very important, and behind the proposal is the Volkswagen diesel scandal. I can tell you that I met the commissioner with a very small group of experts in 2017, and the commissioner was very much concerned that class actions in the US were very much successful, and there was nothing similar at the European level, and so the Commission was pushing to adopt respective instrument. The idea is that qualified entities shall bring those actions, and qualified entities are mainly consumer associations. They shall act on behalf of the individual consumers. The lawmaking process has already started. Parliament has stepped in. The basic idea of entrusting qualified entities has been maintained, is generally accepted. Now negotiators are dealing with the concept of the qualified entity. What shall be excluded is that these representative entities which shall bring the collective actions are influenced by lawyers, so ad hoc models. Yeah, you create a vehicle which brings the action, but the vehicle is mainly dominated by the lawyers representing the vehicle before court. This shall be excluded, and even worse, there is of course a danger if you have a non-profit organization bringing such a kind of claim that the other side, the entrepreneur, the defendants, finally finance the qualified entity in order to get a good result. A low settlement. So transparency is a very important issue here. The Parliament was also very much concerned about punitive damages. So there is a lot of lobbying going on in Brussels and in Strasbourg. And there is still the idea that a European ombudsman might be the best solution, but ombudsmen are known in Scandinavia and not so known in other parts of the European Union. The last development is from 6 November of this year, and now in the Council they have clarified what they want to do. They want to include both domestic and cross-border collective actions. And cross-border representative action, according to the definition in Article 3, means a representative action brought in a member state other than that in which the qualified entity is designated. So, for instance, a Luxembourgish qualified entity, a consumer association, brings a claim against a German company on behalf of all Luxembourgish consumers in Germany. This would be the idea of the new instrument. So, what is the state of affairs? What can we find at the moment already in different sectors? And this is very typical for collective redress. It comes rather from substantive law, and in some areas of substantive law, the EU lawmaker has already adopted some, not comprehensive, but some sectorial provisions on collective redress. So, where are we now? The most important area is, of course, consumer protection law. In consumer protection law, so far, we have collective redress with regard to injunctive relief. This is the regulation out of 2009. Now the Commission wants to enlarge the scope of this procedural device, the possibility to go for injunctive relief. And if you look at the very bottom, you can see that the new proposal really enlarges the scope of the new instrument from 13 to 59 different EU directives on consumer protection. So there are two enlargements. One is not only injunctive relief, but also damages. And the second one is not only 13, but 59 different directives. Second area, I already mentioned it, is data protection. The General Data Protection Regulation provides for a combination of public and private enforcement. So on the one hand side, qualified entities shall bring civil lawsuits. On the other hand, also authorities for the protection of data and of individuals shall also be empowered to sanction businesses, individuals who do not comply with the requirements of the General Data Protection Regulation. At the same time, also the Court of Justice is quite active in this area, and data protection will be one of the incoming areas of a lot of case law of the court. And one interesting case was Fashion ID, which was decided in July of this year. There it was about the question whether the current directive on data protection, which does not provide for any collective relief, prohibits the introduction of injunctions brought by consumer association by the member states. And it was eBay which was behind the case. And they really went on by saying, as the directive does not provide for collective relief, it is excluded and member states are not free to introduce it. This was very critically commented by the Court of Justice, and they also referred to the new situation now that we already have the General Data Protection Regulation, which explicitly opens up collective redress in this regard. Third area, also interesting, financial disputes. We just talked about shareholders' action in the diesel scandal. But here we don't have many instruments so far. The moment we have the new directive on consumer protection as proposed by the European Commission, at least parts of it will be covered as far as consumers are concerned. But then investors have to be consumers, and very often we have institutional investors who are not included in this area. But there is a very interesting and prominent case which has been filed to the Court of Justice, and I mention it here at the very bottom of my slide. It's a preliminary reference filed by the Dutch Supreme Court. And you should know that in the Netherlands, they have a very specific law on the settlement of mass claims, which borrows a lot from the US, by the way, from settlement class actions. And under this law, investors can get compensation for losses on the financial market in the following way. They set up a foundation. Yeah, this is this Vereniging van something. I don't speak Dutch and I don't try it here. And they represent all people who got, all victims, yeah? All investors who got losses. And they can bring an action for settlement in the Dutch courts against the business. And in this case here, it's BP. It's a company which has its seat in the UK. It's about the Deepwater Horizon incident in 2010. And the Dutch association, the Dutch foundation, says we are representing all investors from the Netherlands who got losses. Therefore, the place of the harm, we come back to what Marta just has explained, is located in the Netherlands. The Dutch Supreme Court was not so much convinced that this is really a ground of jurisdiction. The court said in the case law of the Court of Justice, so far, there is not only the place of the damage, you need something more. On the other hand, the foundation mainly represents Dutch investors, but not only. And then we have Article 7, number 2, for damages which might have occurred elsewhere. So this would enlarge the scope of 7, number 2 considerably. It remains to be seen what the court will decide. Do you know what this is? This is a photo which shows to you that a lawsuit of 650,000 pages was filed with Daimler Chrysler in Stuttgart. And they came with a lorry to hand over the documents. And this gives you an idea of the IT equipment of German courts. It is not existing. Yeah? So everything has to be made on paper. And you can imagine how much time such a lawsuit might cost. So cartel damages is a very specific area. You just mentioned it. And the Court of Justice has already given one important judgment which facilitates collective redress in this regard. It is a CDC case which was decided in 2015. And in this case, the court permitted the lawsuits which also englobe assigned claims. So you can see we have different areas. We have cartel damages, we have financial losses, we have data protection, we have consumer protection. And the sectorial approaches are not based on the same principles. And in addition, we have the Brussels 1 bis regulation, which applies to all civil and commercial matters. And as a matter of principle, with the exception of public enforcement, all these cases are, of course, civil and commercial. We have heard it this morning. So what is a new technique applied here? And maybe then I stop and we can a little bit discuss. The most interesting basic approach, I already mentioned it, is that these collective remedies shall be based or shall be brought by so-called qualified entities. So the idea is in the member states, there are consumer associations, other entities. They have the main task of bringing representative actions for consumers in the interest of consumers. There are different ways of representing these collective interests to the civil courts. And Article 3 shall operate as a kind of door opener. So the French Consumer Protection Association shall be entitled to bring the claim against a German defendant at the seat of the German defendant on behalf of all consumers which have been harmed by a specific behavior. This is an approach which is not found in the Brussels 1 bis regulation. It's not about standing. And this here is about the mutual recognition of standing. And at the same time, the draft directive expands a lot and works a lot on the criteria of the qualified entity, transparency, independence from the other side, and also a structure which has been established in advance in order to avoid ad hoc qualified entities bringing cross-border cases. It remains to be seen whether this is a very good model. It works in Germany. It is working in the Volkswagen case to some extent. But on the other hand, the question is whether consumer associations as non-profit organizations are really able to organize collective claims. This is a real business. This is a huge task. You need a lot of investment to notify, for instance, potential represented plaintiffs, etc. You need an organization. You need cases, recurring cases, to fund such a business. And the problem is, if it is non-profit, maybe we do not find many organizations being able to bring these collective claims. And on the other hand, let me be quite frank, I'm not a big fan of class actions. But on the other hand, organizing lawsuits is a typical task for whom? For lawyers. And excluding lawyers from this collective redress to a large extent, to my opinion, does not make much sense. I could talk for another hour. I stop myself here. Thank you very much.